Hi, my name is David Holt. I'm the Research and Emerging Technologies Librarian here at Santa Clara Law, and this is the screencast for Federal and California Administrative Law. To begin, let's go over what is administrative law. Basically, administrative law is going to include the adjudication and rulemaking that is done by either federal or state government agencies. These agencies have been authorized to promulgate regulations under what's called an enabling statute to regulate within their assigned subject areas. Why is this important? Well, to be honest, administrative law impacts our daily lives much more frequently and pervasively than statutory law. If you think about the areas of your life that have been impacted by regulatory law, would include how regulations inspect our food. They include the building codes for the buildings that are constructed that we reside in or work in. Highway safety, virtually everything we purchase, use for transport, eat or drink is regulated by one or more state or federal administrative agency. So let's dive into administrative law here. The first aspect of administrative law is that there will be an enabling statute. An administrative agency can only promulgate regulations within the purview given to it by an enabling statute. The enabling statute is created by the legislative authority, and so for California that would be our state legislature. For the federal government that would be Congress. The enabling statute will be codified in the respective code for either state or federal, and it authorizes the administrative agency to regulate within the purview given to it by the statute. There is a very important model document that regulates the administrative procedure process, and that is the Administrative Procedure Act, the APA. The APA governs the rulemaking and adjudicative process of federal administrative agencies, but the APA has been adopted by nearly all of the states. Most states use a very similar, if not identical, structure provided by the APA. The APA arose after the rise of the modern regulatory state and the New Deal that was created by FDR. Prior to that, there wasn't a standardized procedure for the administrative process. Of course, there was a huge change in terms of administrative law brought on by the New Deal and the end of World War II. Prior to the FDR administration, the administrative framework for both state and federal governments was very, very different than it was after the end of FDR's administration. We can divide the administrative process really into two halves, although there is some blurring between these two, and that is rulemaking and adjudication. Rulemaking, as the name implies, is the process by which regulations are created. That process is itself divided into three categories: informal, formal, and hybrid, which is a mix of informal and formal. And then adjudication. Adjudication is the process in which complaints are heard by an administrative agency. It is also a process for rulemaking by some agencies. So there is some blurring between rulemaking and adjudication here. Some administrative agencies, both state or federal, engage in a rulemaking process via adjudication. I strongly recommend that you take the administrative law course offered at Santa Clara Law during the second half of your second year or during your third year. It's an area of law that is frequently neglected by law students, something that many students regret after graduation, and it is an invaluable course. Okay, so informal rulemaking is governed under Section 553 of the APA. It's also called notice and comment rulemaking. It's probably the most pervasive and popular method for rulemaking. Notice and comment rulemaking means that notice is given in a particular document for the federal government, that is the Federal Register, that gives notice to impacted parties and the general public, and enables a comment period by which parties and the public can submit their opinions, documents regarding the proposed rule. The comment period then ends. The administrative agency is obliged to respond to those comments and then to make a final decision as to whether modifications should be made to the proposal, whether the proposal should be accepted or rejected. So the steps in informal rulemaking. First step is the investigation by an agency as to whether a new regulation is needed. Preparation for the proposed rule. For the federal government, there's also what's called an OMB review of the proposal, and this is in response to an executive order that was issued during the Reagan administration. Then publication after the proposed rule has been finalized, publication in the Federal Register. If this was a state regulation, this would be published in the state equivalent, which I will show you in just a second. There'll be then a public comment period for the federal government, that's 60 days. And then the agency prepares its final rule, responds to the public comments that were submitted, and then finally publication of the final rule if the agency does decide to proceed and adopt the rule in the Federal Register, which is later codified in the CFR, which is the Code of Federal Regulations. Informal rulemaking decision making procedures are not invoked unless the enabling statute contains that phrase. Hybrid rulemaking. That you may have already encountered in law school are your immigration courts. Those are an administrative adjudication, and parties can appeal from an adverse ruling in an administrative court from the INS or from Federal Register. Think of the Federal Register as the daily work log of regulatory activity by the Federal much activity in the CFR. The CFR itself is updated in halves. And so the first half of the CFR is updated, and then 6 months later, the other half is updated. This was true for print, but we now have an electronic equivalent for the CFR, which I'm going to show you in a regulations. Barclays is owned outright by Westlaw. The electronic edition itself is done by Westlaw. And I should mention an if you do a Google search for the current CFR, let's go down to Patents, Trademarks, and Copyrights, which is Title 37. And you'll see that there are parts of the CFR and also a table of contents. You can browse through either on the eCFR website. Click on any of these links and it's going to show you the current text for the CFR. The Federal Register has its own website. It is simply federalregister.gov. It has an issue, of course, that's published every day, and it breaks down its content as to what was included in that issue. We'll see that when comments close, the type of rule that's being proposed, it's Federal Register citation. Notice the FR is the Blue Book stem. Where in print in the Federal Register this is located, the applicable CFR section that is being modified or created by this proposal. And there's going to be a document or docket number that used to be the system by which members of the public could acquire the documents that were submitted for public comment. That has now changed, however. We have a website called regulations.gov. Regulations.gov is a website by which members of the public or affected can submit documents and comments for proposed federal rules and regulations. We can click today to see what public comment periods are ending. If we were to click on any of these, it gives us the proposed regulation. We can open the docket folder and see the primary document, some agency material, law library services to prisoners as a part of my professional organization as a law librarian. We were alerted last year to a proposed state regulation in New York that was to remove print legal collections from state libraries in New York. This is the notice of proposal here by the State Commission of Correction, the ID number, the text, opposition to the proposal, why we thought this was a bad idea, gave a So the proposal for the rule was published in New York's equivalent of the Federal Register. We call this the Z Register in California. There's an equivalent one for all of the states. This is the public comment that was